Good afternoon, everyone. Welcome to the webinar, Understanding Fair Housing Rights and Ohio Landlord-Tenant Laws. My name is Maurice Stewart, and I'm the Director of Inclusive Excellence at the UC Alumni Association. Today, we'll be discussing important information related to fair housing and your rights as a tenant in Ohio. Our guest speaker, UC alumna, Latanya Springs, will provide valuable insights and practical advice. Before we begin, please note that this webinar is being recorded. If you have any questions during the presentation, please feel free to use the chat box. And note, this program is part of the Alumni Success Series featuring UC alumni with subject matter expertise on a variety of topics. The information provided within this program is for informational purposes only and does not constitute legal, medical, financial, investment, tax, or any other form of advice. The opinions, viewpoints, and beliefs expressed belong to the presenter alone and not those of the University of Cincinnati Alumni Association, UC Foundation, UC, or UC Health. The information is provided as is. No representations are made that the content is error-free, and any reliance or actions taken or not taken based on information contained in this program is solely at your own risk. I'd like to introduce you all to Latanya Springs. Um, I'm delighted to introduce her, and Latanya is a former colleague of mine. Latanya, she's the Assistant Director of Housing Opportunities Made Equal, Home, um, uh, a Cincinnati-based civil rights nonprofit working to eliminate housing discrimination. With a degree in communications from the University of Cincinnati College of Arts and Sciences and an executive MBA from Xavier University, Latanya is a dedicated advocate for fair housing. A lifelong Cincinnatian, she grew up in the Mount Auburn neighborhood and currently resides on the Cincinnati's west side. And Latanya is known for her passion for gardening. So without further ado, I'll pass this on to Latanya.
Thank you, Maurice. Um, Once again, my name is Latanya Springs, and I'm the Assistant Director here at Housing Opportunities Made Equal, better known as HOME. So here at HOME, we have a couple of divisions. We have the Enforcement Division. We are the division that handles all of the discrimination complaints. It's myself along with two other colleagues. We all take the calls, investigate, along with the testing coordinator. We go out into the community when we have discrimination, and we send out testers, to test the market to see if there's actual discrimination. We have a tenant advocacy section up under enforcement, and they handle tenant landlord complaints. They're kind of the go-between between the landlord and the tenant. We have a free housing mediation service that we use sometimes to help us, settle some of those tenant landlords. We have some funding where we help families stay in school districts in Price Hill. So we pay rent and utilities to make sure that the children stay in the school district for that whole year, because what we've learned is that kids do not thrive if they're jumping from school district to school district. We have an education and outreach division where we actually have staff who go out and do courses for consumers and providers to give them what is fair housing, what is tenant landlord law? And we have a Spanish language services where we have two advocates who actually speak Spanish, and they handle calls from the Hispanic community. We have a new division, which is a research and advocacy division, where they keep us involved on all housing legislation and policies so that we can always be current on the information that we're telling the community. And all of our services are free. And if need be, you can remain anonymous. So this is just fair housing, what it looks like. So we call this home by the numbers. So in 2021, if you look at the fair housing calls received by protected class, if you look into 2020 and 2021, you see that more than half of our calls are from people with disability. And what we found out is that that's the number one reason that people call home, is that they've been discriminated against because they are disabled. And this is not a local trend. This is a national trend. All of the fair housing agencies who report to the National Fair Housing Alliance say that that is the number one reason. Then if you look at the next protected class, which is race. We get about 46% of those calls are race. Sex is about 17 or 18, and that is really up this year in 2024. I don't know what happened during the pandemic, but the sexual harassment complaints for 2024 is really up. And then we have some others that don't really fall into any category. It could be criminal records, it could be income. Um, and then if you look at the familiar status complaints, we get about 16% in 2020, about 19% in 2021. National origin complaints in 2020, we got about 5% of our calls were based on that, 8% in 2021. And we really didn't have any religion complaints in those 2 years. So why is fair housing so important? Fair housing is important because it gives everyone equal access to rental housing and home ownership opportunities. And we found out that that's the cornerstone of our founding principles and justice. So it is extremely disturbing when new immigrants, minorities, family with children, members of the LGBTQ plus community, and persons with disabilities are denied housing of their choice. We here at home, we feel that you should be able to live wherever you choose to live. So, and we're beginning to really look at how does housing impact the community. So choosing a new home may not only change your address, but it can also change your outlook. It could help your health because we know in certain communities there's few food deserts, environmental stressors. You might need networking opportunities. It might be social versus interaction, like feeling of fulfillment or despair, and sometimes aspirations. So the history of the Fair Housing Act. The Fair Housing Act was passed in 1968. It happened right after the assassination of Dr. Martin Luther King Jr. So the official name of the Fair Housing Act was Title 8 of the Civil Rights Act of 1968. This came about right after Dr. King was assassinated. The legislative body looked and said, how can I honor King's legacy? And that's when they developed the Fair Housing Act. So if you look at the Fair Housing Act, a lot of people call and they say that we've been discriminated against. But there are certain classes that fall up under the National Fair Housing Act. So when we say race, we mean like race and color. That's the color of your skin. When we say sex for the national, that means like sex as a gender, being a female or being a male. Recently, we have been able to use sexual harassment falls under as sex of a gender because a lot of the victims are female, but we have had males who have been sexually harassed in housing as well. Religion, that's if you want to practice Muslim, Jewish, Catholic, Baptist. Um, National origin means like you come from a different country other than America. Familiar status is families that have children under 18 in the home. It could be where you had them, where you adopted them, and disability, it could be mental or physical. And I will go into all of these a little deeper later in the presentation. So if we look at the Ohio protections, other than the National Fair Housing Act, Ohio has basically said included ancestry. So when we look at ancestry, we look at appellation here in Ohio. Military status means that you cannot be denied because of your military status. If we look at the Cincinnati protections, they have included on top of the national in the state of Ohio, they have added sexual orientation, they have added transgender status, they have added marital status, and they have added appellation origin. For those who are on the webinar that are from Covington and Kentucky. On top of the national protections, Kentucky has added sexual harassment, and in Indiana, on top of the national protections, they have added ancestry. So um, if you look at the Fair Housing Act, it does not say sexual orientation, but we look at that as gender, um, and we fight for it under that sex as a gender. Um, but if we can't use the Fair Housing Act, if it's in the city of Cincinnati, we can file directly, with the city of Cincinnati. So where does these laws apply? Who do they apply to and what types of housing? So these laws apply to houses, apartments, condos, mobile homes, dorm rooms, nursing homes, emergency shelters, transitional housing, extended stay hotels, and subsidized housing. So what providers does this apply to? Landlords, apartment agents, managers, real estate agents, condo association managers, the condo and HO board members, builders, developers, lenders, insurers, and agents, advertising media, and multiple listing services, MLS. So what does housing discrimination look like? Housing discrimination looks like a refusal to rent or sell housing based on any of those protective classes that we talked about in the last slide. Refusal to negotiate based on those protective classes. Setting of different terms and conditions or privileges based on protective class. Falsely denying that housing is available for inspection, sale, or rental based on protective classes. Persuading homeowners to sell or rent dwellings by suggesting that people of a particular protective class have moved or are about to move into the neighborhood. Showing prospective clients properties in certain areas while avoiding to show them properties in other areas that they might be qualified for due to protective classes. We call that steering. Denying a person access to membership or participation in any organization, faculty, or service related to the sale or rental of dwellings of discrimination against persons in the terms of conditions of such access, membership, or participations due to protective class. Advertising a home for rent or sale using language that is considered discriminatory towards members of a protective class. I will give you a couple of examples of that. An example would be refusing to rent to families with children on the second floor because of a fall risk. It is up to the parents if they want to live on the first, second, third, front, back of a building, and they are responsible for the safety of their child. Telling a person with disabilities you cannot rent a unit because there are stairs and you might be a fall risk. Those are just some of the types of the discrimination that we have seen, or telling families with children that they have to live, say, in the closer to a playground because we are not going to allow children, to play in this area. Those are just a few of what does housing discrimination look like. So, discrimination based on disability. Home recently settled a case in which a major name extended stay hotel discriminated against a guest by not allowing her to stay with an emotional support cat. And when you look at that, their reasoning was because extended stay hotels, they felt were not covered under the Fair Housing Act. Extended stay hotels are covered under the Fair Housing Act because you are there for long periods of time. It's not like your typical hotels where you go and stay maybe the weekend or a week. These are hotels that you can stay unlimited amounts of times, up to years. And you cannot not allow an emotional support animal A person with a disability who needs an emotional support animal gets to choose the animal that is going to help them emotionally. I don't know if you heard about the lady in Blue Ash who the city of Blue Ash was telling her that she was could not have her chickens. Well, Home represented her and she was able to keep her chickens because those were the emotional support animals that she needed to live in the city of Blue Ash. So um, that's just a couple of examples of discrimination based on disability. So we don't want to scare people into selling. We call that blockbusting. You can't tell people where to live. You can't steer. We talked about that earlier. Families with children, you can't say you can only live on the first floor. People with disabilities, you have to live on the first floor. And redlining was real big in Cincinnati. And this is where the lending of the mortgage companies was basically saying that areas where African Americans live, they had like a red line around it. And you do not want to make a loan in that area because those people will forfeit on those loans. But it really was not um, any proof that that would happen. But those were maps, neighborhoods that African Americans were not able to participate fully in the lending of monies to get homes because of redlining. So, when I said familiar status, so familiar status is an adult 18 and older with children 17 and under. So it could be a pregnant woman, it could be a parent adult with legal custody of children or seeking custody, people going through the adoption process, single heads of households, national origin. Um, you could find yourself in violation of the Fair Housing Act if you turn a person away because they have an accent or you have communication difficulties. You can't ask for things for people who are not from here that you don't ask from everybody else. Um, and they are, if you have documentation that you hand out and you have migrants or immigrants in your community who do not understand, say, English, then you must provide them documentation in their native language if they request it. Um, and you can't ask for certain documents because we have driver's license. Not all immigrants have driver's license or state IDs. So we have some examples of things that they could have the green card, they could have the temporary work permits. All of those things are things that they could have that possibly could you could use um, instead of the actual IDs. So we try to say if you stay consistent on the items that you use, if you have any questions, please call home and we can get you a full list. So discrimination based on sex or gender. Sexual orientation and gender identity may apply as sex and gender discrimination. Um, we also have sexual harassment, which falls under that. For subsidized units or units who get federal funding, the Violence Against Women Act does apply. It provides additional protections in subsidized properties. And what that looks like is that a woman who is a victim of domestic violence under the Violence Against Women Act can request to move or break their lease without penalties to find safe houses or safe homes away from the abuser. And what we're beginning to see now is that a lot of the nuisance ordinance that are being um, that are coming about are beginning to be pragmatic because they're saying that they're a public nuisance. And these are calls for police or emergency services. And in those ordinances should be exceptions for domestic violence. But what we're finding out is that a lot of these municipalities who are looking at the nuisance ordinance, they are not paying attention to women who are a victim of domestic violence and are using all the police runs to the building as saying that this property is a public nuisance and advising all of the landlords to evict the tenants or pay high fines or penalties. So we are looking into that as sex or gender discrimination under the Fair Housing Act. So sexual harassment can be committed by the landlord, real estate agent, building manager, maintenance person. And what we want everybody to understand is that any employee that you employ, um, you are responsible for their actions. So if a person is being harassed sexually, we can just give you some examples. There is help. Requesting rent to be paid in sexual favors instead of money. Saying I will not come in to do repairs unless I get some type of sexual benefit. Using any sexual comments or sexual words in front of tenants and their families. Unwanted touching, a housing provider or their employee refusing to help after being informed about sexual harassment. Those are examples of sexual harassment. So if a tenant comes to you and say that the maintenance man made sexual suggested comments, she has made you aware that some unwanted sexual harassment has happened, and you, as the owner or landlord, are responsible to investigate and alleviate those advances, or you will be held responsible for the actions of your employee. So when we look at sexual harassment, it's two types of things that we really pay attention to is the quid pro quo. This happens when you require a person to submit to an unwelcome request to engage in sexual conduct as a condition of obtaining or maintaining housing or housing related services. The other one that a lot of people don't realize is the hostile environment. Hostile environment harassment occurs when a housing provider subjects a person to severe or persuasive unwelcome sexual content that interferes with the sale, rental, availability, or terms, conditions of the housing related services. So a person who is living in a unit and is being harassed or having unwelcome advances, that creates a hostile environment for the victim of the sexual harassment. So even if the victim submitted to the consensual unwanted sexual conduct, it still is harassment, sexual harassment. It still violates fair housing. And I'll just give you what we've been told is that a lot of people, men and women, who have been in these types of situations are telling the housing advocates that they felt that if they did not do that, they would be in jeopardy of losing their housing. So you have a person of power who is doing sexual advancement to a person who has no power, like I need my housing. So that's like the hostile environment, and it can be sexual harassment. And if a person complains about the sexual harassment and is threatened with eviction or the rent increases or the management decides that we're not going to do repairs, or they say you can't come into the community room. Um, those all fall into retaliation for me complaining of a protective class. So when you hear us use disability, the Fair Housing Act says that a person is deemed disabled uh, if they have a physical or mental impairment that substantially limits one or more life, major life activities. It could be breathing, it could be walking, it could be seeing, or anyone having a record of having that impairment or being regarded as having such an impairment. That is how we define disability in the Fair Housing Act. So, major life functions: seeing, hearing, breathing, walking, learning, speaking, working, performing manual tasks, caring for oneself. So we have a report that says 29% of Cincinnati area household has at least one person who has a disability under the federal fair housing guidelines. The other ones that where the disability includes comes in, it could be people who have the HIV infection. It could be people who were currently under the drug addiction, but not currently using the illegal use or the illegal drug, might be in treatment. Um, those people are considered to be disabled. So some recent local cases, we settled a housing discrimination case where a client who was disabled was denied housing because they needed around the clock caregiving. And so the housing provider would not allow their care providers to come to care for this person because they felt that this person needed to be in a facility if they needed around the clock care. Um, that is discriminatory because when we talked earlier, we said that everybody has a right to live where they want to live. And if this person wants to live, say in housing, and these care providers is how that they can live independently, they should be allowed to do that. Um, then we recently settled a case where management denied an amputee a key to access his apartment through the garage because they felt that the garage had steps and this person should not be doing steps. It was better if the person was on the front of the building and could, then walk into the unit without using steps. But once again, the request was to be allowed to use the garage to go up the 4 steps to get to the door and not be on the street, which was was kind of like commercial on one side, a lot of big trucks and traffic where this person may not have been able to get out quick enough um, on the street side with all of the traffic. And we did file and we did settle that case. Another case where a prospective tenant was told by an apartment complex that they did not accept people who received disability income. Basically, that is discrimination because that person is only receiving that income because of the disability. So you cannot deny a person who receives Social Security disability. And the reason that was given was because it would affect the people who worked and lived there. That is why we don't accept Social Security disability. So we did settle that case, and the client was able to receive some monetary settlement. So we will talk a little bit about how to address people with disabilities. The word is able body. is not recommended. Instead, use person without a disability. So people first language uses wheelchair instead of wheelchair bound. People with disabilities instead of handicap or disabled. People without disabilities instead of normal people. Accessible parking bathroom instead of handicap parking bathroom. Successful instead of overcome disability. That was just a little how we have been told that this community would like us to uh, talk about them as we're describing this. So when it comes to admissions and screenings, the general rule is landlords may not ask questions about an applicant's disability. The only concern is that can they pay the rent? Do they get along with their neighbors, maintain the dwelling, and obey basic rules about conduct? So they cannot be turned down because of a mental disability, but they can be denied based on actual behaviors. Reports from previous landlords about disruptive behavior or criminal background checks. While landlords are entitled to proceed with court eviction for lease violations, treating people with disabilities more harshly is a violation of the Fair Housing Act. So what is a reasonable accommodation? A reasonable accommodation are changes in rules, policies, practices, or services so that a person with a disability has an equal opportunity to use and enjoy the housing. So if I'm a person with a disability, what does this look like? It looks like if I have the emotional support animal and there is a no pet policy, then my request is that since I am disabled and I need this emotional support animal, I can ask the housing provider to disregard that no pet policy because my emotional support animal is not my pet, is an aid that I need to live in this unit independently. So I'm asking you to change the rules to allow me to have my emotional support animal. So examples are, like I said, service animals or emotional support animals, caregivers living in an apartment, additional time to move, copies of notices sent to the caregiver, assigned parking spaces. Those are examples of reasonable accommodations. So accommodations must be requested. In order to get a change in a rule or policy, the tenant must request it. An accommodation may be requested at any time. It could be when I'm doing the application, while I'm living there, or even while the landlord is trying to evict me. What I have to provide if I'm a person who with a disability, you can ask for proof that I need that. A housing provider is not required. You can't ask what my disability is, but if I am a person that you can't see the disability and I just want a hot tub, you can say, hey, I need information, why you would need a hot tub. And a landlord, so what I would have to get, and I wouldn't be able to get it because I'm not disabled. I wouldn't be able to get a notice. And so you can, a lot of times people think that it has to be a medical doctor. The Federal Fair Housing Act says that has to come from a licensed professional who has knowledge of the disability. So it can be my therapist, it could be a caseworker, it could be my social worker, it could be the doctor, it could be the therapist, it could be my pastor. So the decision to request an accommodation is entirely on the tenant, and you as a landlord should not be looking at anybody with a um, disability and saying that I think this would be better for you. So just keep that in mind moving forward. So things to know about. reasonable accommodation, the housing provider cannot ask about the nature of it or the extent of this person's disability beyond verifying that I have the disability and there's a need for an accommodation. So you can't ask what type of medicine I'm on. You can't ask for my medical records. You can't ask questions like how long have you been disabled? And then can they charge fees for reasonable accommodations? No, they cannot. They cannot charge a pet deposit for an assistance or a service animal because they're not pets. You can't charge a fee if a tenant needs to move to another unit because that unit is unsuitable for their disability. You cannot charge a fee for breaking a lease if the unit is no longer appropriate given the disability of the tenant. And you cannot charge extra for first floor units or units by the elevator that is necessary for a tenant who has a disability. So, how do reasonable accommodations need to be made? The tenant is responsible for making a request. It can be verbal or in writing. The request can be made at any point during the tenancy. After the request is made, the housing provider can ask for documentation connecting the disability to the person's request if it is not apparent. If you can see it, then you cannot ask. They don't need the documentation. We already talked about who can provide the documentation, and the letter stating the need for a reasonable accommodation or a reasonable modification. This letter is required, won't disclose the diagnosis. It won't give you the nature. It won't give you the extent. It will only tell you that this person has a disability, and because of this disability, these are things that they need, like a ramp for a person with a wheelchair. That's a reasonable modification. So those are the type of things that you will see in a reasonable accommodation letter. So, and a lot of people don't realize that the reasonable accommodation request is supposed to be an interactive process. So if I am a person who's making a reasonable accommodation request, you cannot just say no and that's the end. You have to say, I can't do that, but this is something else as I'm offering. And then we supposed to go back and forth until we agree to what the accommodation is. And if you don't respond to a reasonable accommodation request, that's just a flat out refusal, and that's when you might get in trouble. So the landlord can do the undue burden test. I was talking about a landlord is not required to provide an accommodation if the landlord can show that doing so will create an undue financial or administrative burden on the landlord. So the fundamental test is that the Fair Housing Act does not require landlords to enact significant changes in its programs or service to accommodate the special needs of tenants with disabilities. If that happens, then the accommodation request may be denied if it endangers the health and safety of the building or other tenants. And a reasonable modification is a structural change made to an existing premises occupied or to be occupied by a person. That's kind of like what I told you about, like the ramp. It could be asking that the handles on the stove be in the front instead of behind for people in wheelchairs. So those are just a couple of examples of what a reasonable modification looks like. So it could be ramps, it could be widen the doors, it could be grab doors, it could be flashing light for smoke detector, levered door handles, and lower kitchen counters and cabinets. So reasonable modifications in private housing, landlord must allow, but the tenant must pay. If federal funding, the landlord must pay for the modifications. And I won't touch on that one. Service animals, a lot of landlords will ask, like, what does the emotional support animal do for you? But they're mixing up emotional support animals and service animals. So service animal jobs, they're retrieving dropped items, they're opening and closing doors, they're turning lights on and off, pulling a wheelchair up a slope, waking someone with post-traumatic stress from a nightmare, licking a seasoned person to help end the seizure, alerting a diabetic to dangerous shifts in blood sugar, or bracing an unsteady or unbalanced handler. So those are jobs that a service animal might do. An emotional support animal, they're not there to do a job. They're more comfort animals or therapy dogs. Um, so support animals provide companionship, relieve loneliness, and sometimes help with depression, anxiety, and certain phobias. But they don't have a special training to perform a task. And when you heard about the unique animals, I gave you a case earlier when I talked about the lady with the chickens. Like I said, a person with a disability gets to choose their emotional support animals or the type of animal that they want. And can a person have more than one service or emotional support animal? And I can tell you that I have heard of that, but what we always ask is that the statement must include what each animal does for the person who's needing these multiple emotional support animals. Property managers or housing providers are allowed to ask for vaccination records. Um, so any vaccinations, you can ask for that. Um, assisted animals, service animals are permitted in all areas of the home or common areas and public accommodations within a housing complex. Emotional support and companion animals can be restricted to the home and common area spaces. We talked about how a housing provider can legally deny a request. These are the design and construction. So buildings built after March 13th, 1991, they have to have an accessible building entrance on an accessible route. They must have accessible and usable public and common use areas, usable doors, accessible routes into and through unit, light switches, electrical outlets, thermostats, and other environmental controls in accessible locations, reinforced walls and bathrooms for later installation of grab bars, usable kitchens, and bathrooms. So, exploring gray areas, um, fair housing laws prohibit making, printing, or publishing any notice, statement, or advertisement that indicates any preference, limitations, or discrimination based on a protective class. So fair housing laws cover all types of statements, advertisement, brochures, and this includes the rental process, brochures, ads in print, visual media, the internet, social media, or signs. And I'm just going to skip a couple of these. I want to get a little bit of the Ohio Tenant Landlord Law. So this is what Ohio says that the tenant and the landlord must do. So the relationship between a landlord and tenant, these are your rules and regulations. We have no rent control in Ohio. So let's just jump right in. So it says the landlord responsibilities. They said landlords must make repairs and keep premises in fit and habitable condition. If making repairs does not happen, the tenant may put rent in escrow. It says the landlord will comply with all local building, health, and safety codes, give 24-hour notice to enter at reasonable times, supply running hot water, reasonable heat at all times, keep all supplied fixtures and appliances in safe working condition, provide trash receptacles if 4 or more units in a building, maintain the building common areas, and return the security deposit within 30 days of the tenant leaving minus repair costs. Examples of self-help evictions is changing the locks, turning off heat or water, taking or moving tenant belongings, spreading rumors about the tenant, and refusing to repair something that affects the habitability of the unit. So these are illegal eviction tactics. So the tenant is responsible to comply with all housing, health, and safety codes, allow the landlord to enter for inspections or repair when given a proper notice. We say proper notice is 24 hours. Operate all fixtures properly, keep premises safe and sanitary, do not intentionally destroy or damage property, and don't enjoy the peaceful enjoyment of the premises for neighbors. So these are just some general guidelines that, we're looking at. The housing provider has the right to look at your income and rental history. Um, and all of this should be written out as to what they do or what rules or requirements they use to get an apartment. Um, so best first come, first serve is a nice way to look at. Never work on assumptions. Respond to all inquiries. Um, and you might have other type of inquiries. It might be a TTY relay service, and it might be people who um, have speech characteristics or dialects to identify a caller's race or origin or ancestry or religion, and it would be discriminatory not to call that person back. So we talked about this requiring IDs for applicants is okay, but requiring a specific form of photo ID, driver's license may have a disproportionate adverse effect on members of a certain protected class, and because people from other countries may not have the driver's license, but they may have other forms of ID. Is it okay to run a joint credit check for married couples and to ask unmarried couples to file separate applications and undergo separate credit checks since they do not have the community property status of a marital couple? So, foreign applicants, um, an applicant cannot be turned away because of an accent or because communication has been challenging. You might need to have translators, promotional materials, applications, or rental agreements to meet all needs of the applicants. So it makes good business sense to translate some basic forms if the property community is in a community with many foreign language speakers. So don't ask for proof of legal status just because they have an accent, speaks English poorly, or looks foreign. Don't do that. Um, Everyone is asked for proof of legal residency. If an immigrant has no social security number or has little or no rental or employment history, you may use alternative documents that are available to determine if an immigrant is able to pay rent and follow rules. So legal reasons that you can reject a person: fails to complete and sign rental application or agreement, falsifies information on any of the forms, writes an initial check not honored by the bank, cannot provide identification, or plans to use premises for other than living purposes. So if they don't have any references, has pets and your policy prohibits them except for assistance and service, has a history of property destruction, has many unpaid bills, doesn't earn enough income to pay rent, and can't pay the security deposit. So there is a new rule on criminal records, but it's only in regards to people who have a subsidy on the unit. So you cannot turn down a person just because they have a criminal record. Um, we're looking into landlords who have the blanket bans, who won't rent to people because they've ever had a record, felony in a record, because these policies are having a discriminatory effect, desperate impact on certain communities. And what we're asking is that every case be determined on a case by case basis. Seeing criminals or poor tenants is not enough. Warn people based upon arrest alone is no good because arrest alone are proof, they're not proof of guilt. And we think that landlords should take a more individualized approach, and look at the criminal conduct to see if it poses a risk to the safety and health of the housing community. Being a smoker is not protected under the Fair Housing Law, so housing providers can set and enforce any rules they like about smoking. Um, General harassment involves very negative actions that are taken because of someone's protective class. Housing providers are responsible for the behavior of their employees and vendors. The best preventive strategy is to write and periodically distribute a non-harassment policy to all residents, employees, contractors, and to train employees on how to prevent and remedy all forms of harassment. If a resident reports harassment, respond quickly and effectively and follow up to ensure that the problem does not reoccur. Tenant on tenant harassment violence, if there are threats of violence, that's a 911 call. Non-emergencies, residents, you probably just doing an investigation. We suggest that you start an investigation right away, and view both parties. Let them know what your rules are around harassment and document the complaint and investigation results in both tenants' files. If there is, if the investigation shows that there is a harassment, then I suggest that you go to whatever your policy says. You can proceed with disciplinary action up to and including eviction. If an harassment cannot be verified, you can just remind everyone that you have looked into it. Go back to your commitment of housing environment being free of harassment, and promptly inform the complaining resident of the investigation results and monitor this situation moving forward. And that is my presentation on fair housing and tenant landlord law here in Cincinnati.
Thank you, Latanya. And I wanted to see if anyone had any questions. I want to see if I can get everyone on the screen. Give me one moment. Quick sec. Thank you, Latanya. So everyone should be able to unmute themselves. So if anyone has any questions. All right.
I have,
Yes, go ahead, Emily.